Right, so here we're looking at methods of alternative dispute resolution. So if you have a civil problem, so you want to sue somebody, for example, these are options instead of going to court. So we've already looked at the problems that the court process is very, very expensive. It's very, very time consuming. These are alternative ways of dealing with your dispute, but without having to go through the court system, which is obviously a positive. Right, so down the left-hand side, then you can see here there's 4 types of ADR, alternative dispute resolution, going from negotiation, mediation, conciliation, and then finishing off with arbitration. Okay, so it is an 18-mark question, so you need to make sure you do include all of what's in these boxes. This bit is worth 9 marks, which is in great, and then the other 3 are worth 9 overall. Okay. Right, so the first type of alternative dispute resolution is negotiation. So this is where you and the other party are coming to an agreement yourselves. So very much like everyday life, really. You have a fallout with one of your mates, and you'll probably sit down, chat it out, or text it out, and you'll sort it out. That's what negotiation is all about. You and the other party reaching an agreement yourselves, right? Nobody else is helping. You could use a solicitor, I suppose, if you wanted to be formal, but realistically it's not needed. So obviously it's very cheap because you just sit down and deal with it. So this would generally be for things like businesses or individuals that have got some form of problem. Okay. Mediation takes it a little bit further then. So mediation, you do have a third person, right? So it says there, neutral third person. You do have somebody involved, but that person is a facilitator. What that means is they'll normally sit down and they'll say, right, Rebina, it's your turn. Right, Alison, it's your turn. Rebina, it's your turn. Or if you're not in the same room, they'll pass messages across. But the third party doesn't generally offer their opinion unless you ask for it. The whole point of them is to facilitate and just make sure that the process runs as smoothly as possible. Alright? They're not there to tell you what to do, basically. The decision is still yours. Okay? We can have a formalised settlement conference. So this is basically mediation, but a little bit more formal. You get a mini trial and the person will help you come to an agreement. An example that you can use then, I always use the FMA, the Family Mediators Association. This deals with family situations, so it could be custody, it could be trying to see your kid 1 extra day a week, it could be anything really that's a family situation that would be a civil case, where as a result you would normally go to court, but you're going to try and resolve that family situation through mediation instead. Conciliation, similar to mediation, but the conciliator is allowed to suggest options to you, right? What I mean by this is they're allowed to say, well, have you not thought about this? How about you take Saturday, you take Sunday, and then you switch over every now and then? So they've got the option there to give you some form of suggestions that you might want to use, okay? They still don't make the decision, that's you. But they have the option to sort of give you a couple of ideas. Okay, for this one, I always use ACAS. So the Advisory Conciliation and Arbitration Service. Generally, this is sort of like disputes at work, industrial disputes, but you can solve them through it. And ACAS has got their own website, and it allows you to come up with some form of compromise. These bullets down here are quite important. So both mediation and conciliation allow the parties to have full control. So you can back out and say, nah, I'm not doing this anymore. You can do that at any point. Okay, so if you've done 1 full day of mediation, you don't think it's going to work, back out, and the same with conciliation. Now, mediation and conciliation are not binding, right? Unless you put it into a legally binding contract. So the problem that we've got is people will have these decisions that they'll come up with, but they won't be binding unless they turn around and make it into a contract. So the enforceability is quite difficult. So you might have agreed in your conciliation meeting that you would pay £2,000. It's hard to enforce that. So you need to get it into a contract to make it a little bit easier. Last bit then is arbitration. So this is worth half your marks, and it's important that you get everything that you need for this. So first of all, it's governed by the Arbitration Act. So you need to include the Act of Parliament to get your 18 out of 18. Okay. The parties voluntarily agree to allow their dispute to be left to an arbitrator or a panel of arbitrators. Right. So we've gone from negotiation where there isn't a third party, mediation where the third party kind of just sits there and helps, conciliation where the third party actually says, look, why don't you do this, why don't you do this, and now arbitration, the third party is actually making the final decision. So we've gone from no involvement up here to full involvement where they are making that full decision for you. Okay, now it would normally be happening in writing, so arbitration is written. You would write down in a contract that if any time you have any problems, it would go through arbitration. Okay. Now, a lot of businesses will agree this via their contract. So if, let's just say, you're a clothes shop and you have a contract with a clothes manufacturer to make jeans, dresses, etc., right? You might have in your contract with that clothes maker that in the result of any disagreement, you will have an arbitrator that will decide the outcome. So this is normally businesses so that somebody else decides the outcome in the hope that the parties can still work together afterwards. Okay. So either name somebody that will do it or it'll help you choose the arbitrator to suit you both. Whatever the arbitrator says is binding. So with the others, these are only binding if it's put in a contract, right? Negotiation isn't binding at all. Arbitration is binding upon both parties. So whatever the arbitrator says, you have to follow. Okay. Finally then, whatever they do say, whatever damages they might pay or who might win, is known as an award. And you can't really do anything about that unless it is really, really, really stupid. So it can be challenged in the courts for serious irregularity. So if it's obviously proven that they have just totally come up with a wrong idea, they've not even done it normally, or they're arguing a point of law, the law that they've used to decide that you are the loser is wrong, obviously you do want to then challenge that in the courts. But realistically, arbitrators are experts in their fields. It would be very, 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 very unlikely that you would need to be able to take this to court. Your example, I always use ABTA, so Association of British Travel Agents. So if you're booking package holidays, it'll be ATOL protected, ABTA protected. All that's meaning is if you're not happy with the holiday, you complain to Thomas Cook, they don't offer you compensation, you can go through arbitration, through ABTA, and they will obviously help you then come to a compromise. Okay. So it just gives you some form of avenue to go to, and the arbitrator will make the decision, not you, not Thomas Cook. It'll be a third party that's independent that will be experts in that sort of field of area, so like your travel area, making sure that you did pay for your 5-star hotel, not a 1-star little shack with no toilet, etc. Okay. Right, so this is your 18-mark question then, and it's looking at methods of alternative dispute resolution. Okay. It is worth 18 marks. It's a very, very good question should it come up. You would be expected to describe and illustrate. So these examples I've given you, Family Mediators Association, ACAS and ABTA, you will be expected to use those as well, seeing as they're examples, so they're your illustration part.